Are victims of domestic violence second-class citizens? Well, the Home Office thinks so, especially during this pandemic. Want to know why? Watch the video. This is Kareesha Turner, your human rights barrister. The figures surrounding domestic violence and abuse in the United Kingdom make for depressing reading. Help should be available to all domestic abuse survivors, no matter their immigration status. The pandemic has seen an increase in cases of domestic violence, and the number of domestic violence remedy orders shows a mixed picture. The weekly number of non-molestation applications and the number of orders granted recently during lockdown and Lot 1 and 2 show an increase. London's Metropolitan Police Service received an increased number for calls, of course, for service for domestic incidents following lockdown, and this is partly due perhaps to people spending a lot of time at home. But the very nature of the crime, domestic violence, is a hidden crime that is not often reported to the police. And this situation is made worse if you are a migrant, man or woman. This is particularly true of female migrants who may have concerns about approaching the authorities due to their immigration status. A person with an insecure status or even with limited leave to remain in the United Kingdom may find it extremely difficult to go to the authorities. The reason for that is, like I said, the nature of the crime. It's a hidden crime, but often victims and witnesses alike who report to the police have found their data shared with the Home Office, a process which has been encouraged by the government in a hope to meet their removal targets. Some time back, a document was leaked showing secretive data sharing arrangement whereby victims and witnesses of crime were frequently reported to immigration enforcement by the police. Since the policy was initiated, the number of women who have been removed following reports of domestic abuse has risen from 12% to 30%, showing a worrying trend of criminalising the victims of crime simply to improve immigration figures. Effectively, fear of being treated as a criminal rather than as a victim of crime has led many women to stay silent for much longer. And if we look at the current state of the law on migrants and domestic violence, we will look at two recent cases that dealt with domestic violence. The first one is the case of F.A. Sudan against the Secretary of State. The Court of Appeal confirmed that for someone to apply to stay in the United Kingdom as a victim of domestic violence, they must have been a partner of either a British national or someone who's settled here, which means it excludes people or spouses of a person with limited leave, or people seeking asylum, spouses of people seeking asylum. But even if you are able to overcome this hurdle, the next and perhaps the biggest challenge is to convince the Secretary of State that you are indeed a victim of domestic violence. Last year, we had the case of Suleiman against the Secretary of State, and it was a welcome reminder from the High Court that the demands of fairness require the Home Office to consider all the evidence and to come to a proper conclusion on that evidence. Now, one would have thought that this is what the Home Office does anyway, but the High Court had to remind them. But as we know, domestic violence is bigger than just physical abuse. It can be psychological, sexual, emotional, and the Home Office has a document, a policy document, that has a list of what will in fact fall as a domestic abuse. But how do you prove these in order to satisfy the Secretary of State or the Home Office? And that's where it gets quite interesting. And although, like I said, we do have a document, the Home Office has a document, a policy, in my experience with these cases, nothing short than a contemporaneous video of these victims being beaten or raped would satisfy the Home Office. The rules themselves do not specify the evidence that must be provided. So there's a lot of ambiguity there, and perhaps the victim has nothing else but his or her own account. It leaves the Home Office leeway to interpret these evidences or to assess the value of such evidence. So it's important to get proper legal advice on the evidence before making such a claim. I am aware that there are a lot of charities who help, and a big thank you to them. But I cannot emphasize this enough. Getting legal advice on your evidence is paramount if you're about to make such a claim. Things that I always advise my clients to do in such a situation is keep a diary, use your phone if you can as a recorder, get proper witness statement, and do not be afraid to call your doctor. These are sort of practical advices, but when it comes to the claim itself, get proper legal advice. What is the bigger solution? Is there a bigger solution? Data sharing and keeping the victims safe. Perhaps a formal creation of a firewall where personal information about victims and witnesses will not be shared with the Home Office for enforcement purposes. This might help victims come forward. The other one would be to review the Domestic Abuse Act, because it does not guarantee or offer any protection to migrants who are victims of abuse. And there's always the fear of removal. The rules themselves need to be reviewed, because we are essentially saying to these women, you came here as a dependent and you have no expectation of having a life outside your abuser. So effectively, the domestic violence route is closed if you have a wrong or the wrong immigration history. I have also found during my practice that some women continue to stay in an abusive situation only because they have limited leave, or they're worried that they would be asked to leave by the Home Office. And for some of these women, returning to their home country is not an option. They're scared of honor killing and the likes. So if you have, or you are about to make an application, but do not fall within the rules, the only recourse may perhaps be an application on the basis of your family life under Article 8, or an application for leave outside the rules. But if you are a victim of domestic violence, the last thing you want to do is deal with a refusal from the Home Office. Do not remain trapped with your abuser. If you would like to make an application, or you want further advice on making such a claim, or challenge such a refusal, you can contact me, or you can speak to your lawyer. Thank you for watching Kareesha Law. Subscribe and hit that notification button for the next update.